Diversity is important in the court. Current Washington Supreme Court is the most diverse. I'm told by the legal community, my lawyer friends, that the current Washington Supreme Court is the most diverse Supreme Court in the country, if not ever. So my question to Justice Whitener is it really a good idea to have such divergent point of view? And does that diversity, or possibly, I call it divergent or diversity, depending on where you're looking at it, would that create a lack of consensus among a collegial court? In other words, does diversity cause discord and destabilize the law and eventually society? What do you think about that, Justice Whitener?
Absolutely. First of all, diversity does not mean diversity of thought. You have a number of different types of diversity. I gave you some of the labels used to identify me and diversify me as far as a person. In regards to profession, I also have a very diverse professional background. What that does is it brings that lens to the discussion and helps it be more informed, because our community and our society is multicultural and multi-ethnic and multi-professional. That's what it does. That's what diversity does. It brings depth to the discussion, and it brings different lens to bear on the issue that is being heard. And if there is experience in the law, as far as practical experience, that comes to bear on the issue as well, which is why I believe that legal practical experience matters, where I have the practical experience of having been a lawyer, a practicing lawyer, having been a judicial officer, and now sitting on the high court. That matters in regards to how the law is viewed, how it is interpreted, because I understand the application aspect of the law, where my opponent here does not. He has theories, and he has exercised those theories in certain circumstances, but he has not practiced law, because if he had, he would have been committing a crime. You have to have certain competencies to pass the bar. That is one thing. And then get experience, be bar certified, and then get experience. My opponent passed the bar he was sworn in as an attorney this past April. He got bar certified this past May. And as he has admitted in his opening statement, he has never practiced law. There's a reason. Practical experience matters.
Okay. And Monique, your question for candidate Serns.
Actually, Justice Whitener kind of touched on what I was going to ask Dr. Serns. The question has to do with his qualifications. And I read on Dr. Serns' website, as well as Ballotpedia, the vast variety of experiences. And Dr. Serns, you're very educated. You have a PhD from 1992 and a JD from 1999. And so you've had a lot of education as well as theories, and you also apply a lot of that knowledge in various capacity as an educator, an HR administrator, but you don't have any practical application of the judicial process, as Justice Whitener just mentioned. So how do you think you are going to apply the law and also form consensus with the fellow justices on the current bench if you don't have an overall understanding of how all of these theories apply to the court of law in Washington state? And I'll have a follow-up question. I'll have you address that. How do you see your role fitting in if you don't have any practical experience in the judicial sense?
I'll try to keep this to 2 minutes. I'd like to quickly respond to your question to Justice Whitener. I highly value diversity. I think she spoke exactly correctly. Diversity in characteristics of people is entirely different than diversity of thought. I think we should be proud of the fact that we have such a diverse Supreme Court, but we don't necessarily have diversity of thought. We have 5 of the current 9 justices have been appointed and have had the opportunity to run as an incumbent then before they were ever elected. I would have preferred running for an open seat and not running against Justice Whitener because I respect the diversity of personality and so forth. But to go back to your question, as far as it goes back to the experience question, I think there is a particular value in having unconventional experience sometimes. I think it can give people the ability to have insights that's actually a strength to an organization. They have insights that because they're coming from a different perspective. Certainly there's a learning curve whenever you do something different. An example I want to refer to the people of Seattle will know well, and particularly those who have been around for a while. In 1995, John Stanford was selected as a superintendent of schools for Seattle Public Schools. He'd never been a teacher, never been a school administrator, but he did an outstanding job. He was a retired Army general, and trust me, I'm not trying to compare my accomplishments to John Stanford. He's an icon, but my point is that unconventional preparation sometimes gives you as good or better preparation to have insight that's different from those who have had
that's time.
Experience.
That's time. Thank you.
Been confronted with during the election, and what have you learned from this process? Dr. Serns first, and I'd like to ask the same question of Justice Whitener.
2 minutes.
I agree with the statement. It's a very humbling experience. It's a very good experience for both candidates and the public, I believe. I think that everyone grows from discussing the different options. One of the issues that's been on my mind that's probably most difficult for me to address is, as I mentioned, I've been a champion of diversity throughout my career. And in that respect, I felt somewhat uncomfortable running against Justice Whitener. As I mentioned, I would much prefer to have run it for an open seat. But we've had 2 open seats in the Washington Supreme Court races in the last 28 years because of appointments by governors. So it's almost impossible to run for an open seat. But that has caused me to really think through and analyze why I'm running. And as I've stated before, it's important for me that there's diversity of thought as well as other types of diversity, and that our courts are respected for being nonpartisan. That I do respect Justice Whitener, and I think we agree with each other on many key issues.
And any follow-up, Monique?
What have you learned? Well, you kind of touched on it, but I'll ask if you would like to articulate any more what you've learned from the process of running against an incumbent such as Justice Whitener.
30 seconds.
Well, it's humbling to hear Justice Whitener's experience. I think I've been misunderstood as feeling that experience is not important. I think experience is extremely important, and her experience is very impressive. My case is that I just think there's sometimes alternative experiences, like I mentioned earlier, that can also give you the skill set. Wouldn't think it would be even more audacious for somebody to be 25 years old and running for this position, but I have had a lot of experiences that I think contribute to the skill set.
And time. And Justice Whitener, same question. Would you like Monique to repeat the question?
Yes, please.
Okay. So in September of 2010, there's a debate between now Justice Wiggins and retired Justice Sanders. Justice Wiggins said during his running for the Supreme Court seat at the time, the election is a humbling process. You basically go and lay bare your soul, and you submit yourself to questions talk to folks, and it forces a candidate to confront issues that you may not have had to confront before. What issues have you been confronted with during this election, and what have you learned from this process?
Well, as far as issues have been confronted with, most of it was brought about by COVID, and that is, I was appointed, or at least announced, by Governor Inslee on April 17th. And by the way, that's the same day I believe my opponent was being sworn in as an attorney. I started the job by leaving Pierce County Superior Court on April 23rd, and then, of course, got sworn in as a Supreme Court Justice on April 24th, during COVID, by the way, and then had 1 week to get up to speed for oral arguments. So the challenge for me was trying to navigate this big move from Superior Court to the High Court during this pandemic with such a short time frame, having never, of course, done appellate work like this. I was a Board of Industrial Insurance Appeals judge, so I've written opinions, and then find myself 1 month later, or actually a few weeks later, in a campaign. So what has been difficult is maneuvering from my past position to this position, getting up to speed, which of course my experience came to play. And then of course, trying to figure out how do I campaign in a virtual world. So my campaigning, my entire life since COVID hit has been in this platform. What I've learned is I had to meet and be vetted by the legal community. So I've been vetted and found exceptionally well qualified by 13 bar associations, but all in a virtual world. So whereas I would have had to travel to meet them, this platform actually made it a little better, but it's very challenging in that there's so many Zoom things that can be fit into a day that it's very exhausting. So that was challenging for me. And then of course, finding myself in a race with an opponent who's never practiced law,
And
is challenging.
that's time. Thank you.
My question has to do with the affordability and access to justice. The average person doesn't have any idea how the judiciary system works. They don't read your opinions, concurring or dissenting. Why should they vote for this position? And also, how would they get informed in their decision making who to vote for in the Supreme Court races? Justice Whitener.
60 seconds.
A number of things. First of all, yes, they may not write or read the court's decision, but my approach since joining the judiciary hasn't changed since I got to the Supreme Court. I'm very active in the community. I do a lot of educating in the community in regards to the law. I also have worked over the years of bringing the community into our court so they can see the court at work, because the court impacts, especially the trial level courts, impact all facets of our lives, more so than the higher courts, really. So that's where the true impact the court can have on a person's life is seen. In regards to bringing them into the court and educating them, it's educating them on how the court works, what the court can do for them. Unfortunately, we tend to see individuals come before the court involuntarily after they've gotten into trouble. So I have made an effort of going out into the community. I have many things that I do out in the community to teach, as well as Lincoln high school students. And then I've also put on programs in the court where I bring the community in to have them see their court at work. We work for them. So therefore, we need to interact with them, and not only when we're ordering different things that affect their lives.
And Dr. Serns, same question. Would you like the question repeated?
No, I think I have it. I think that the lack of understanding of issues is an extreme problem in all of voting, not just for judicial branch, but for legislative and executive branch. So I think there needs to be a great deal of effort on all of our parts to do a better job of educating. I'd like to give kudos to Justice Whitener, for her street law course that she teaches, and that's something I'd like to become involved in too. I think helping young people understand the importance of civics and how to vote on different issues while they're still in school before they even become adults is probably the best place to start. But we just need to look for ways of constantly educating people. It's a huge challenge.